today is types of majorities. See, whenever we talk about the parliament as an institution, or for that matter legislature as an institution, legislature in India works through a mechanism called as resolutions, motions and bills. What are resolutions, motions and bills? Resolutions and motions are basically a mechanism which highlight or which tends to pronounce what the house wants. The house works through this mechanism. So if there is a if there is any motion like something called as no confidence motion, if it passes, or if the house passes any motion, what it basically does is, through passing that motion, by ensuring that the motion is passed, the will of the house, that is what is the will of the house, that will of the house is expressed. Clear? So this is what is the idea of motions. And then there is some bills. What are bills? Bills are again basically bills are what are presented in the house. Once a bill is passed, it becomes a law. Until unless the bill is passed and given its assent by the president, that very document is not called as a law. It is formally known as a bill. Clear? So what are motions and what are bills? Motions are basically a mechanism through which the house expresses what it wants or what is the will. Similarly, bills are those instruments that are used to pass a law. Any law, before it is passed by both the houses and assented by the president, it is a bill. It is called as a bill. Clear? Now, whenever we talk about various types of bills or various types of motions that are there, it requires to pass the house, both the houses, that is the Rajya Sabha, the Lok Sabha, or for that matter the state legislative assemblies. It requires a very specific kind of majority. It requires a very specific kind of majority. And that is what we are going to discuss in types of majorities. Clear? Because from now onwards, when I start discussing the constitution itself, I am going to talk about various provisions, and in various provisions I am going to talk about either an amendment or a bill being passed. In that case, you should actually understand what is the meaning of the term when I say a term something called as simple majority, or if I say something called as an effective majority or a special majority. What does that mean is something that you should be absolutely clear with. Let's start with an idea called as quorum. What is the quorum? Quorum simply means the minimum number of members that needs to be present for the house to take up its business. Until unless these minimum number of members are not present, the house does not work. The house does not start working. And according to the Constitution of India, this is 1/10 of the total membership. So if we talk about the Lok Sabha, so in Lok Sabha, how many members are there? How many members are there in the Lok Sabha? 5? 552 is the maximum sanctioned strength. The maximum number of members as of today is 545. Clear? 545. So at least there should be 55 members that should be present in the house for the house to take up its proceedings. So, whenever, if you at any point of time, if you see the legislative procedures, working of the house, now again the winter session has started. So you would find that as soon as every day in the morning, whenever the house meets, it will start in this manner. The presiding officer, first of all, standing up, and then obviously they would first look at the quorum. So thus, before actually starting with the proceedings of the house, the members that the presiding officer that would be there, they would always mention this idea. The quorum has been achieved, so we are going to proceed with the house. So this is always that is done. Every session starts with this very idea. So for the house to work, whether it is the Lok Sabha or whether it is the Rajya Sabha, for it to work, it requires at least 1/10 of the members to be present in the house. If they are not present, in that case, working the house will not take up its proceedings, its business. Clear? So once the quorum is achieved, let's come to the types of majority. First is called as simple majority. First is called as simple majority. Now, this is the most important kind of majority. You would find that generally the whatever business is taken up in the house, that is basically taken up through the use of simple majority. Clear? What is simple majority? You can write this. It means a majority of more than 50% of the members, present and voting. It is not more than 50% of the total membership of the house. Clear? It's not more than 50% of the total membership of the house. It is more than 50% of the members present and voting. Clear? Present and voting. It is also called as functional majority. Clear? Why do we call it as functional majority? Because generally you would find that whatever legislative business is carried out, that legislative business is carried out through the use of, simple majority. Clear? Next, absolute majority. Absolute majority. What is it? It means more than 50% of the total strength of the house. Clear? So as we say, as we said, 545 members. So you would find that whenever we talk about Lok Sabha, in Lok Sabha we during elections we tend to look at this particular figure, 273. Now we tend to look at this particular figure, whether any political party gets 273 or not. What is 273? Any political party getting 273 seats, it simply means that that political party has absolute majority. Like previously in the last Lok Sabha, the only one party, that is the BJP, had 282 members, which means it had absolute majority. In fact, this year they have 303 members, which means again this year they have absolute majority. The key point here being that whenever we talk about absolute majority, absolute majority is nowhere needed. That is in terms of legislative business. To carry out a legislative business, it is nowhere needed that in any passing of any resolution, any motion or any bill, do we require absolute majority? No. But absolute majority is politically significant. Why? Because once a political party gets absolute majority, it means political stability. It means political stability. So last year you can see that there were the 5 years that were there, we knew that this political party is going to be in power, and whatever happens, there will not be political instability. That means the political party will not go out of power. And similarly, in this year also we know that since from 2019 onwards till to 2024, that is the next general elections to the Lok Sabha that is there, we know that this political party, the BJP, is going to be in power. Why? Because they have absolute majority. They have absolute majority. Clear? So absolute majority implies political stability. Though it is nowhere needed, but it implies political stability. Write down this. Absolute majority is not required individually to take up legislative business, however it implies political stability. Now why are we saying, underline the term individually. Why are we saying individually? Because when we talk about special majority, you would find that there is in certain cases requirement of absolute majority, but absolute majority is not individually required anywhere. Clear? What does this mean? I'll clarify this when I come to special majority. Third is effective majority. Effective majority. It means more than 50% of the effective strength of the house. Effective strength of the house. That is total strength minus vacancies. Total strength minus vacancies. This is what is meant by effective majority. So you would find effective strength and total strength may be different. At certain point it may be different, like total strength minus vacancies. You would find that from time to time there are some seats that tend to be vacant, or it goes vacant for various reasons. An individual member might be disqualified, an individual member might be removed, or the individual might resign for various reasons, or the individual might pass away in office itself. So for various reasons you would find that sometimes the majority, that is the total strength that is there, that total strength is not achieved. Why? Because there is something called as vacancies, because of vacancies. Like if you are reading the newspaper itself, you must have seen that during this political crisis that is going on in Maharashtra, because of this, one of the MPs of Shiv Sena, he resigned from Lok Sabha. He resigned from Lok Sabha. Because why did he resign from Lok Sabha? Because both of these political parties, they were in coalition, and they contested election in coalition. Because The coalition was voted, not an individual member. So that is the reason why, citing that ground, he resigned from office. Clear? So that is also something that happens. Now, is effective majority required? Yes. In certain cases, effective majority is required. What are those cases? You can write this down. Very important. It is according to me, it is a very potent prelims question. Effective majority. First, removal of the vice president. Removal of the vice president. The resolution passed in the Rajya Sabha. The resolution passed in the Rajya Sabha shall be passed by an effective majority. Shall be passed by an effective majority. In brackets, write Article 67 Clause B. Article 67 Clause B. This is how you write clause. So when I say clause, it means this. If I say Article 67 Clause B subclause, which means, again, subclause means there will be one more bracket after this. Okay. So Article 67 of the Constitution talks about removal of the vice president. And how is the vice president removed? The process is initiated always in the Rajya Sabha, and a Rajya Sabha passes the resolution. Passes a resolution for this effect, that is removing the vice president by an effective majority. Clear? Second, impeachment of whom? Vice president is not impeached. Vice president is removed. Vice president is not impeached. We only impeach the president of India. Otherwise, everyone is removed. Clear? Yes, we only impeach the president. Otherwise, everyone is removed. Technically speaking, everyone is removed. No one is impeached except for the president. There is this, the idea of impeachment. The term impeachment has a very different meaning. It's different from removal. Impeachment means an individual is basically being removed from office, but that individual is removed from office not by the executive but by the legislature. If legislature takes that up, that is called as impeachment. Otherwise, everyone is removed. Clear? Second, removal of the speaker. Removal of the speaker, deputy speaker of legislative assemblies and Lok Sabha. Of legislative assemblies and Lok Sabha. Clear? So the speaker and deputy speaker that are there, they are also removed by effective majority. And third, removal of deputy chairman. Removal of deputy chairman of the Rajya Sabha and chairman and deputy chairman of legislative councils. Chairman and deputy chairman of legislative councils. What are legislative councils? Legislative councils are the upper house in the state. Legislative councils are the upper house in the state. So the presiding officer of the Rajya Sabha is the vice president. And the vice president is elected not just by the Rajya Sabha. There is an election wherein both the houses, the Lok Sabha and the Rajya Sabha, both of them elect the vice president. Basically in India, the vice president has only one function, that is acting as the presiding officer of the Rajya Sabha. Except for that, constitutionally speaking, he does not have any other functions. He only acts as the presiding officer of the Rajya Sabha. Clear? In his absence, there is an individual who is elected from the Rajya Sabha who acts as the presiding officer. Now, when the vice president is not present in the house, and that individual is called as the deputy chairman. Now, that individual is called as the deputy chairman of the Rajya Sabha. Similarly, when we talk about the state legislative councils, now some states in India, they have two houses, the upper house and the lower house, and whenever we talk about the upper house, again in the upper house, every state which has this upper house elects two individuals, the chairman and the deputy chairman, and both of them, if they are to be removed, they are to be removed by an effective majority. Clear? Absolutely clear? Next, special majority. Special majority. What is a special majority? The best way to define special majority is any other kind of majority which is neither a simple majority nor absolute majority nor effective majority automatically becomes special majority. Clear? So, any majority which is not a part of the majorities that we have discussed till now, it becomes automatically a part of something called as special majority. Clear? Special majority are of various types. There is no one kind of special majority. There are number of types of special majority. Let's discuss them one by one. First, subheading here. First subheading. Majority under Article 249. Majority under Article 249 and 312. That is not less than 312, not less than 2/3 members present and voting, not less than 2/3 members present and voting. Present and voting. So, in certain cases you would find that there is a special majority that is required. That special majority only requires one condition. And what is that condition? That 2/3 members should, the 2/3 members that are there present and voting, the 2/3 members should vote in favor of that particular resolution or bill or a motion. Clear? If 2/3 members that are present and are voting, they vote in favor of the bill, then that majority is achieved. Like two of those conditions that are mentioned in the constitution, under our constitution, is Article 249 and Article 312. Article 249 has to do with something called as the power of the parliament to legislate on state subject. What is it? Forget about it. I am going to deal with it later on as well. I am just informing you so that you are a bit mentally at peace. Otherwise, you will always be thinking, what is this? What is this? Article 312 of the Constitution deals with formation of new All India services. Clear? Formation of new All India services. I hope you know what is All India services. Clear? So, whenever Article 249 or Article 312 is used, that means whenever suppose the parliament has to legislate on a matter that is traditionally a part of state list, what is it I am coming to? In that case, the process is always initiated by the Rajya Sabha, and the process is initiated when a resolution to this effect is passed by the Rajya Sabha with the said majority, that is 2/3 members, at least 2/3 members present and voting. Clear? Second, majority under Article 368. 368. What is Article 368? It deals with amendments. That is, how can the constitution be amended? Article 368 deals with that. And what kind of majority is required there? Write this. An amendment should be passed by not less than 2/3 members present and voting, not less than 2/3 members present and voting, and a majority of total membership of the house. Total membership of the house. So that there is no confusion, let's understand this through an example. If you understand this through an example, you would get what this is all about. So suppose the government or the parliament has to pass an amendment bill. The parliament has to pass an amendment bill. And in Lok Sabha, the bill is presented, and in the Lok Sabha right now, in the Lok Sabha currently there are 300 members who are attending the session. 300 members are attending the session. So the first criteria says at least 2/3 members present and voting, which means at least 200 members should vote in favor of the bill. So the first condition is at least 200 members should vote in favor of the bill so that the bill passes. The second condition says also, that means it says that an additional condition is majority of the total membership of the house. Now what is the total membership? 545. And what is the majority of the total membership of the house? As I said, 273. Now if suppose 200 members vote in favor of the bill, is the second condition satisfied? No, the second condition is not satisfied. That is, 273 members have not voted in favor of the bill. Clear? So are you getting this? This is an additional requirement. If you compare the majority, the first type, that is under Article 249 and under Article 312, in that case the condition is satisfied because 2/3 members have voted in favor of the bill or the resolution passes. But when you take up a kind of majority that is mentioned under Article 368, there is an additional condition that you have to satisfy. Along with 2/3 members present and voting, along with that an additional condition. What is that additional condition? The additional condition is at least the more than 50% of the total membership of the house. They should that majority should also be present. So until unless it gets 273 vote in the Lok Sabha, an amendment bill can never pass. An amendment bill can never pass. And see, it's not that if 273 members have voted in favor, though automatically the amendment bill passes. No, because suppose all of the members are present. So now this will not satisfy. That is, if you look at the 2/3 majority here present and voting that is required of 545, that will be a much greater number than 200. So again, if 273 members are voting in favor, it does not mean that the bill automatically has passed. Both the condition needs to be satisfied. What is the first condition? At least 2/3 members present and voting, and at least it should also be more than the majority of the total membership of the house. Clear? Are you getting this idea? Now are you getting this? Because see, I have already talked about quorum, and quorum is 1/10, which means 55 members if they are present in the Lok Sabha. So suppose 60 members are present in the Lok Sabha. So the amendment bill can be taken up for vote. And suppose out of the 60 members, if 41 vote in favor of the bill, so the first condition is satisfied, but the second is not. Clear? Are you getting this? This is the reason why an additional check has been imposed. What is that additional check? That is, it also requires the majority of the total membership of the House. Understood? No confusions? No confusions? And what is the kind of majority? That is, under Article 368, the kind of majority that is there. Where are these required under our constitution? You should know that as well. Clear? Write this. Where is it required? First, amendment to the constitution. Amendment to the constitution. Second, removal of judges of Supreme Court and High Court. Removal of judges of Supreme Court and High Court. Third, removal of the Chief Election Commissioner. The Chief Election Commissioner and the Comptroller and Auditor General, CAG, and the Comptroller and Auditor General. Next, under Article 352, yes, fourth is under Article 352, that is approval and continuance. Approval and continuance of national emergency. Approval and continuance of national emergency. And the next point, last point, under Article 169, under Article 169, in the passage of a resolution, passed by the state legislative assembly, for creating or abolishing the upper house of the state, What does this mean? As I said, in some states in India, in some states we also have an upper house, that is Legislative Council. But Legislative Council is not present in all states. Legislative Council is not present in all states. How are Legislative Councils created? The procedure to create Legislative Council is mentioned under Article 169. And it says that for this, through a special majority, a resolution has to be passed by the state legislative assembly. Once it passes the resolution, then it goes to the parliament, and then parliament creates the house. So when it is to be passed in the state legislative assembly, it requires this kind of majority. Clear? Next, third kind of special majority. Third kind, majority under Article 61. Majority under Article 61, that is impeachment of the president. Impeachment of the president. It means not less than two-third of the total strength of the house. Of the total strength of the house. of the total strength of the house. Clear? So this is the only condition, total strength, which means in Rajya Sabha it is 245, in Lok Sabha it is 545, and the total strength, this is the total strength. So 2/3 of the total strength of the concerned house, not present and voting, it is 2/3 of the total strength of the house. So for a resolution to impeach the president requires this kind of majority, and it is only needed to impeach the president. This kind of majority is only needed to impeach the president, not anywhere else.
Excuse me, sir. So is there any difference between total strength and total membership of the house, or it is the same?
Total strength and total membership, it is the same.
It is the same.
Yes, it is the same. Clear? Absolutely clear. These are the types of majority. Within special majority also there are 3 types of special majority that exists. Clear? Clear? So here, no, this particular idea you should learn it. Why you should learn it? Because it is a very potent question when it comes to your prelims examination. No, it is a very potent question when it comes to your prelims examination. The context may be something else, like we have talked about removal of judges of the Supreme Court. If you go back to the year 2019 prelims examination, you would find there was a question asked on what kind of majority that is required to impeach the judge. Okay? It is what kind of majority it requires. That is something that is there. Clear? So you should learn this. If you learn this, you will be absolutely clear in your prelims examination. If ever a question is asked on any such idea, you will be able to deal with it. This is where we end our discussion on types of majority. Now let's start with types of bills. Types of bills. See, basically there are 4 kinds of bills. Ordinary bill, money bill, financial bill, and constitutional amendment bill. Clear? So there are 4 kinds of bills that are there. Let us look at the legislative process, how these are different from each other. When we talk about the ordinary bill, what is meant by an ordinary bill? Simply speaking, ordinary bill means a bill which is ordinary in nature, which means it does not take into account any constitutional amendment, it has nothing to do with it, and it has nothing to do with finance. That is a bill that is an ordinary bill. Clear? Can this bill be introduced in the Rajya Sabha? Yes. That means ordinary bill can be introduced in Lok Sabha or in the Rajya Sabha, any of the houses. Does the bill require prior sanction of the president or prior recommendation of the president? No. Does the bill require president's recommendation to be introduced? No. What is the majority that is required? Simple. Simple majority is required to pass an ordinary bill. Clear? Can there be a constitutional deadlock? That means, do the Rajya Sabha and Lok Sabha, do they enjoy equal powers, equal legislative powers in ordinary bill? Yes. Both the houses, the Rajya Sabha and the Lok Sabha, they enjoy equal powers when it comes to an ordinary bill. Can there be a joint sitting? Can there be a joint sitting to resolve this deadlock? That means if it so happens that Rajya Sabha has rejected the bill or the Lok Sabha has rejected the bill, then can there be a constitutional, a joint sitting that can be called? Yes. Once the bill is passed by the Parliament, it goes to the President for his assent. And does the President enjoy veto powers? Yes. If you remember yesterday's class, we were dealing with something called as checks and balances. And in checks and balances, I said the President or the executive has the power to temporarily or permanently stop a legislation. What is that power known as? It is called as veto powers. Clear? What is veto then? Simple answer to this is veto is a power of the President to either temporarily or permanently stop a legislation. So once a bill has been passed by both the houses, it goes to the President, and the President may say yes, that is give his assent to the bill, or might use veto powers. Clear? So what is an ordinary bill? Ordinary bill can be introduced in both Lok Sabha as well as the Rajya Sabha. It does not require President's prior recommendation. The majority needed to pass it is simple majority. Rajya Sabha and Lok Sabha, both of them enjoy equal powers. Because they enjoy equal powers, there can be a constitutional deadlock. That means one of the house can reject the bill. If one of the house rejects the bill, can a joint sitting be called? Yes, a joint sitting can be called. And once it has been passed by both the houses, can or does the President enjoy veto powers? Yes. Clear? If you know these 6 or 7 points that we have just discussed, you know what is an ordinary bill. Clear? There is one addition to it. Again, a very potent question in your prelims examination. There is one type of ordinary bill that requires prior recommendation of the President. Only one type of ordinary bill is there. That is mentioned under Article 3 of the Constitution. Yes. It is related to the idea that if the Parliament wants to change the name, area, boundaries of any state, in that case the bill that is introduced for that purpose, serving that purpose, that requires a prior recommendation. Clear? So remember, a bill that is introduced, that is an ordinary bill. In an ordinary bill, there is no requirement for President to for his prior recommendation. But yes, once that when a bill is introduced under Article 3, it requires prior recommendation of the President. Clear? What is a money bill? A simple answer to this is any bill or an article of the Constitution, that is Article 110. And Article 110 of the Constitution deals with what is a money bill. But how is money bill different from ordinary bill is what we are going to look at as of now. So money bill, can it be introduced in both the houses? No. It can only be introduced in the Lok Sabha, not in the Rajya Sabha. Does it require President's recommendation, prior recommendation for its introduction? Yes. What kind of majority is required? Simple. Does Rajya Sabha and Lok Sabha enjoy equal legislative powers? No. They do not enjoy equal legislative powers. The Rajya Sabha enjoys absolutely no power with respect to a money bill. except for the fact that they can delay the bill for 14 days. Except for that, there is no power that the Rajya Sabha has. Is joint sitting, can a joint sitting be called? No. Obviously, when there is no scope of constitutional deadlock, in that case, why would the joint sitting be called? Once both the houses passes the bill, it goes to the president. Can president enjoy veto powers? No. The president does not enjoy veto powers when it comes to the money bill. Once it has been passed by the Lok Sabha or the parliament, once it has been passed by the parliament, it goes to the president. The president has to give his assent to the bill. It is as it is mentioned under Article 110, the president shall, the term that is mentioned is shall. The president shall give his assent. So not the president may, it says president shall. It is compulsory on the president to do so. Next, financial bill. Can the financial bill be introduced in the Lok Sabha and the Rajya Sabha? No. It can only be introduced in the Lok Sabha. Does it require the prior recommendation of the president? Yes. It does require the prior recommendation of the president. What kind of majority is required? Again, simple majority is required. Does Rajya Sabha and Lok Sabha enjoy equal legislative powers? Yes. That means, in this case, once the bill is introduced in the Lok Sabha, after that there is no distinction or no difference between the powers that the Lok Sabha and the Rajya Sabha enjoy. Can there be a joint sitting called? Yes. See, joint sitting is called under Article 108 of the Constitution. Does the president enjoy veto powers? Yes. The president enjoys veto powers. Clear? Next, constitutional amendment bill. Again, it can be introduced in the Lok Sabha or the Rajya Sabha. Does it require president's prior recommendation? No. What kind of majority is required? Special majority, not simple, special majority. Does Rajya Sabha and Lok Sabha enjoy equal powers? Yes. Rajya Sabha and Lok Sabha have equal powers. Can a joint sitting be called? No. Even if one of the house defeats a constitutional amendment bill, the bill dies. Bill wahin khatam ho jata hai. The bill is dead. Does the president enjoy veto powers? No. The president does not enjoy veto powers. Clear? So this is what is a constitutional amendment bill. For your knowledge as of today, constitutional amendment bills are also of two types. One which amends the constitution, one bill which amends the constitution but does not affect the status of the state. If the status of the state or the federal nature of or the federal character of Indian constitution is not affected by it, in that case it requires simple majority to be passed by the parliament. When there is a bill that affects the federal nature of the state, and if that bill is passed by the parliament, before president giving his assent to the bill, there should be at least more than 50% of the states, they should say yes to the bill. Until unless the more than 50% of the states they ratify, the term that is used is ratification. Until unless they ratify that particular bill, it is not sent to the president for his assent. Once more than 50% of the state ratify it, it goes to the president. President gives his assent, and then it becomes a law, which means the constitutional amendment is done. Clear? Absolutely clear. So have you understood the idea of majorities? In certain cases, in simple majority, in certain cases, as I said, functional majority. Simple majority is also called as functional majority, because you can see in most of these cases, simple majority is required. Only in case of a constitutional amendment bill, there is a special majority required. As the name suggests, only in special circumstances. For other reasons, all other reasons, you would find only a requirement of a simple majority. Only when there is a special circumstance, when there is a constitutional authority that has to be removed, when there is a special circumstance like creation of a new body of like an all India service, or when the parliament has to legislate on a state subject. Now they are all special circumstances, or we have to impeach the president, or we have to pass a constitutional amendment. All these are special circumstances. Only in that case a special majority is required. Otherwise what we require is a simple majority, and that is the very reason why simple majority is called as functional majority. Clear? Absolutely clear. So now whenever I use the term ordinary bill, money bill, financial bill or constitutional amendment bill, in that case you should automatically, these 5 or 6 points that are there, it should automatically come to your conscience. Yes, I am going to discuss this later on as well. I am going to talk about this later on as well. But for now, so that you are not in a state of confusion until unless I come to this particular topic, it should absolutely be very clear. Clear? Next, give a subheading, right? Federation. Yes. Special majority. Yes, special majority. In addition to that special majority, there is an additional idea, that is ratification of the states. No, GST was a constitutional amendment bill. It was done through a constitutional amendment. You would find Article 269A and Article 279A. These were the two articles that were added, and the constitution was substantially amended when GST was taken up. So it was a constitutional amendment bill.
So for it there will be requirement of
Special
majority.
Special majority along with ratification of the states, because it is amending the federal nature of the country. Clear? Next, federation. See, as it is, whenever we talk about the term federation, the idea of federation that is there, we are going to deal with it in something called as center-state relations. But before we come to center-state relations, before we get into what is center-state relations, etc., you should actually know what is the meaning of these ideas. We are going to again use terms such as a unitary state or a federation. So what is meant by a unitary state or what is meant by a federation? You should know that. So whenever we talk about what kind of government or what kind of political structure is in place in a country, you would find generally there are 3 types of political structures that exist. One is called as a union or a unitary state. The second is called as a federation, and third is called as a confederation, a new type that has evolved. Though we see very less examples of a confederation, but there exist certain examples. Clear? In lot of books that are there with respect to constitution, you would find only 2 types are mentioned, that is federation and unitary state. Confederation, why have I mentioned it? I have mentioned it separately because it has been separately mentioned in your NCERTs. If you look at, if you go through NCERTs, you would find that it mentions 3 types: unitary state, federation and confederation. What is meant by a unitary state? Unitary state simply means that there is no division of powers. There is one union parliament, that is union executive and the union legislature, and the union executive and the union legislature enjoys all powers with respect to legislation and all powers with respect to execution. Okay? Remember, yesterday we were dealing with something called as separation of powers, and in separation of powers we said union, there is something called as legislature, and in legislature the primary responsibility of legislature is what? To make laws. Then there is something called as executive, and it is their responsibility to execute such laws, and then there is a judiciary. Now, when we say legislature and executive, it may so happen that you find that these two organs that are there, they exist separately in the union and in the states. Like in India, you have something called as a union parliament. No, union parliament, and that is the legislature at the center, at the union level. And then you find that every state also has its own legislature. Every state has its own legislatures as well. In fact, in India, there are now 3 union territories which have a legislature. So the states have their own legislatures. This is an example, or this very idea of states having their own legislature. What does it point out to? It points out to the fact that in our country, in India, legislative powers are divided in the union and in the states. So union has its own legislative powers and states have they have their own legislative powers. They have their own legislative subjects and they have their own legislative powers. This is what is called as division of powers. This is what is called as division of powers. Similarly, at the union level we have a union executive headed by the Prime Minister, and then there is a council of ministers. Similarly, in the states also you would find that there is a state level executive also that is present. Who is that? The Chief Minister and the council of ministers. Clear? So there is a union executive and there is a state executive. Union executive has the job of doing what? The primary responsibility of union executive is to execute laws that are made by the parliament. And the state executive does what? It executes laws that are made by the state legislature. Again, this is division of powers. This is division of powers. What you also need to understand is this division of powers that is there in India, or for that matter in any federal setup, this is done what? This is guaranteed by the constitution itself. कहीं और नहीं लिखा होता है. It is mentioned in the constitution itself. Because it is mentioned in the constitution, it ensures that it is difficult to alter. Otherwise, if it is not mentioned in the constitution, what happens? Through an ordinary bill, these changes would be made, and that does not guarantee the state legislatures or the state executive having or enjoying its own powers. It does not guarantee that division of power that we are talking about. So this division of powers, legislative and executive powers exist, and this division that is there, it is guaranteed by the constitution itself. Nowhere else it is guaranteed by the constitution itself. That is what is called as a federation, division of powers. When no such division of powers exist, it is called as a unitary state. It is called as a unitary state. Like you will see in examples, you can see examples in UK. In UK there is one union parliament, and there is a union executive, the Prime Minister and the Council of Ministers, and there is no such authority that is given to any other legislature. In fact, there is no other legislature that exists in the states. In the states, there is no legislature that exists. What you also need to understand here is that if there is a country which has no division of territory, like in India we have union, and then we have 28 states. Now we have 28 states. So this division of territory that is there, this does not mean federation. कि अगर division of territory है, so automatically that would mean federation. No. Division of powers mean federation. Division of territory can be done for administrative purposes as well. Now, why do we divide territory? We divide territory in such units because it becomes then easy for doing what? For administration. So the basic idea, the basic objective of this territorial divisions that you see, that is states, then districts, and then you would find, there are some subdivisions, state, division, subdivision, districts, all these divisions, tehsils, that you see. What is the basic objective of it? The basic objective of it is for administrative convenience. So if you make or if you take up territorial divisions, so what you also need to understand is territorial division is not a guarantee for federation coming into existence. What does lead to federation? Federation means when there is division of powers, and this division of powers is guaranteed by the constitution. This is what is meant by federation. Why I am specifically focusing on this idea? Because you would find even in countries such as UK, there are territorial divisions that exist. Like there are local bodies that are present there. Now you would find that London, if suppose we are talking about a territorial division called as London, so in that you would find that it has its own, it will have its mayor or someone like that, and there would be a small body which would be responsible for law making, etc. All such things are there. But this division of power that has been given to such bodies, it is not guaranteed by the constitution. And at any given point of time, the Union Parliament can make a law and change this. That is not the case when it comes to a federation. In federation, to take up any such amendment or any such alteration of powers that is there, it requires a procedure that is followed, a difficult, strict procedure has been mentioned, and a rigid procedure has been mentioned, and this rigid procedure also has what you can say a say of states in it. Like in India, to take up any such amendment, you require ratification of more than 50% of the states, and similarly is the case in countries such as US also, which is also a federation. But certain countries like UK, or for that matter, countries such as Bangladesh, they are not federations, they are a unitary state. Clear? What is a confederation then? Confederation, you would find there are two prominent examples that are present for this, and the best example of a confederation is European Union. It is the EU, European Union. Why? Because see, there are sovereign states that are present within this setup. Within this this setup that is there, you would find sovereignty has been given to the states. That is not the case when it comes to federation or for that matter a unitary state. We tend to consider India as a country to be sovereign or independent. Now, and India is what, or this country, this territorial extent of this nation that is there, they themselves decide any decisions that they take for themselves, or whether it is related to an internal matter or for that matter an external matter. In a confederation, there are various sovereign units that comprise of a confederation, which means any unit that is there at any given point of time, they can exercise any authority which allows them, which is present to them being a sovereign nation. Like when we talk about EU, you can see very recently Britain voted to exit from the European Union. Now, was there any say of the European Union in it? No. Britain took up a referendum. In the referendum, people wanted that they should no more be a part of EU, and hence Britain decided to exit EU, known as Brexit. जिसकी वजह से political instability is there in EU. Clear? You have seen this? So this is what happens. In a federation, such ideas do not exist. In federation, like in India, we cannot see that, you will not see that the state is, the state is given sovereign powers and the state decides, the state is sovereign in nature. That is not the case. That is not the case. And any such step which will be taken by any such government or by the legislature which exerts sovereignty, if the state starts exerting sovereignty, in that case what is going to happen? In that case the state is going to be dismissed, the government is going to be dismissed, the legislature is going to be dismissed, and the union will start exercising control over the states. So no such provision is mentioned either whenever we talk about a unitary state or for that matter when we talk about a federation. That territorial sovereignty idea that is there, it is very limited when it comes to a federation. In unitary state it is almost absent. Clear? That is an example of a confederation. Another example is Caribbean islands. In Caribbean islands you would find that there are, you must have heard about Jamaica, Trinidad and Tobago. These countries that are there, they are sovereign countries. They are collectively known as the Caribbean islands or the West Indies that we call. West Indies that we call. They are sovereign countries. They are sovereign countries. They have come together and they have formed a common political setup, but they are sovereign countries. If you ever visit there, or even suppose an individual from Jamaica, if the individual wants to visit, suppose Trinidad and Tobago, he would have to have a visa for that. Otherwise, he will not be able to. He will not get permission to visit that particular country. Clear? Similarly is the case with European Union as well. So there are two examples that are present. There are two examples that are present of a confederation type, one of them being the European Union, the other being the Caribbean islands. Clear? So what is a unitary state? There is no division of powers. What is a federation? There is division of powers. What is a confederation? Here there is sovereignty that is provided to the units. They have come together and they have come into an arrangement together, but politically they are sovereigns. They are not dependent on this political setup. They are sovereign, like is the case with the European Union. Clear? Now, why are we discussing this idea? We are discussing this idea because in case of India, India is considered to be a unique federation. India is not like other federations. Now when I say other federations, what I mean? What I mean is an ideal federation. The United States of America is always considered to be an ideal federation. So if you take India's features, India's political features, India's whatever features you would see, and if you try and compare that to that of US, you would find that there are some features that are present in the Indian constitution or the Indian setup, which points out to the fact that India is not a complete federation. Which means, why is then India a unique federation? Or what kind of federation that India is then? This federation is considered, it is said that India is a federation with a unitary tilt. Now what is meant by this India being a federation with a unitary tilt? Yes, it means that the union, that is the center that is there, it has more powers than the states. There are various features starting with Article 1 of the Constitution, Article 3 of the Constitution, emergency provisions, the constitutional bodies such as the Election Commission or the Comptroller and Auditor General, or for that matter the office of the governor, or existence of the offices such as the All India Services, or for that matter if you look at the center-state relations. All these aspects, if all these provisions that you would find that this is presented in such a manner that it gives union more powers than the states. So the union legislature enjoys more powers, the state legislature has less powers, the union executive has much more powers than the state executive. and that is the reason why India's federation is not an ideal federation. Rather, it is said that, if you go by, if you go by a technical language, our federation is defined or described as a sui generic federation, which means of its own kind. Our federation is of its own kind. We have not made an attempt to copy our federation from being an ideal federation like the US. We have taken up a federation that suits us, a federation that is there with a unitary tilt. Clear? And this is the kind of federation that we have. And because of this unitary tilt that is there, over a period of time there have been number of instances and number of provisions of the constitution that have sometimes been misused, and because of this unitary structure that is there, the union government or the union, parliament, the union parliament and the union executive has imposed themselves on the states. You will find that there have been number of such occasions. Since 1967, there have been number of such occasions जहाँ पर union has exerted itself on the states. Clear? So Article 1 of the Constitution, Article 3 of the Constitution, center-state relations, existence of office of governor, existence of emergency provisions, existence of bodies such as the Election Commission or the Comptroller and Auditor General, all of this points out to a unitary tilt. Unitary tilt. Clear? From time to time, that means from almost every day that we take up our class, we are going to discuss about this unitary tilt. Some provisions we'll come across certain provisions, and when we discuss those provisions, I am going to describe this idea of which provisions point out to that unitary tilt. And you will find that this is something that we discuss very frequently in our discussion of the Constitution of India. Clear? So there is no need for a single discussion right now itself. From time to time I will be taking up that. But the point of this discussion was that you understand what is meant by a unitary state, what is meant by a federal state, and third, what is meant by a confederation. Clear? Have you understood this? Clear? Have you understood this? Now let us start with the Constitution itself. Give a subheading, write Preamble. So, what is the preamble? The Constitution of US was the first constitution to have a preamble. It was the first constitution of the constitutions of the world to have a preamble. Indian Constitution also has a preamble which is based on objective resolution, which was drafted and passed drafted and proposed, or more appropriately introduced, drafted and introduced by Jawaharlal Nehru. And it's like a custom for every written constitution to have a preamble. It's customary. You would find every written constitution of the world that is there. Every written constitution of the world has a preamble. Starting with obviously the first constitution, that is US. Preamble of the Indian Constitution was the last thing that the Constituent Assembly did. Now, the last idea that was taken up by the Constituent Assembly was this, the preamble. So, what exactly is the preamble? It is considered to be a prelude or an introduction to the Constitution, comprising of ideals and aspirations of the people of India. It is said to be a comprehensive expression of the philosophy of our Constitution. The philosophy of our Constitution. Comprehensive expression of the philosophy of our Constitution. If you look at the Supreme Court describes the preamble as the key to the minds of constitution makers. Key to the minds of the constitution makers. It is also defined as an identity card to the Constitution. It has also been defined as the identity card to our Constitution. Now, the thing is, why are we saying it is ideals and aspirations of the people? Why do we say it is a comprehensive expression of the philosophy of the Constitution? Or why is the Supreme Court taking this view that it is the key to unravel the minds of our constitution makers? This is what the Supreme Court has to say. In this context, you need to understand this very idea. If you look at the preamble, the preamble of the Constitution of India basically presents, or it has taken into account certain terms. Like you will find the terms such as sovereign, socialist, secular, democratic, republic, justice. All these terms that are there, fraternity, terms such as equality, all these terms that are there, it is mentioned in the preamble. Now, why do we say it is a comprehensive expression of the philosophy or ideals and aspirations of the people? The idea behind this is this, that if you look at the Constitution or the preamble to our Constitution, the preamble to our Constitution is basically describing what is to come, or it is describing as an individual, as a member of the society, what kind of features I would like in the society, what is ideal, what an ideal society looks like, and what kind of member, as a member of the society, what kind of a society I would like. So I would like a society which is just, which is guided by ideas such as justice, guided by ideas such as equality, guided by ideas such as fraternity or brotherhood. What kind of a political structure I would like? I would like a state which is a sovereign state, a secular state, a socialist state, a democratic state. I would like that people people get opportunities of equality, people get opportunities in terms of their status in the society, it should be equal. So why are we saying it to be an expression of ideals and aspirations of the people? Because this is what we want. This is what we want as a member of a society. If you think over it, what kind of society I would like to live in? I would like to live in a society the features of which has been mentioned in the preamble. Or for that matter, when we say comprehensive expression of the philosophy of the constitution. So the basic provisions of the constitutional philosophy that is there. What is our constitution? What is the basic provisions of the constitution? It revolves around the same ideas that have been mentioned in the preamble. So when we talk about fundamental rights, providing for ideas such as right to equality, not just fundamental rights, or for that matter directive principles, even other provisions that are there, it also revolves around the same idea. Like when we talk about the office of the president, or for that matter when we talk about the Lok Sabha, the Rajya Sabha, if you would find the Lok Sabha, Rajya Sabha, the office of the president, vice president, etc. that are there, these political offices that exist, these political offices do not, in the constitution, it is not mentioned a broad criteria or qualification to be the members of this, to become or to get elected to these organizations. Why? Why to this office? Why is it that no such broad qualifications have been mentioned? Because it ensures the idea of equality. Any individual having some basic qualifications can be elected to any political position. The idea of equality. Even you would find that the Constitution of India under Article 327 of the Constitution, it mentions, in the provisions related to elections, it mentions that there will be, the election commission will take up one electoral roll. There will be one electoral roll, like any constituency from which you are a voter. Any constituency from which you are a voter, you would find there is one electoral roll that is there, and that electoral roll has your name. Matlab ye hai, if you whenever you have when you register yourself as a voter, you would find you have something called as a voter serial number that is mentioned, and as soon as you go to the polling station, you inform the individual about your serial number, and it becomes very easy for the individual to find you on that particular list. Now, why is it that there are serial numbers mentioned? Have you thought of it? Because there is only one voter, one electoral roll that is present for the whole constituency. So suppose, if you are a member of a constituency in Delhi, suppose in MP elections there are around 7 constituencies that are there in Lok Sabha elections. So out of that, if you are a member of one constituency, that constituency might have more than 5 lakh voters. So 5 lakh, 10 lakh voters. In Delhi it is as high as 20-25 lakh voters are there. 20-25 lakh voters are registered from one constituency, and you have a serial number, a voter serial number, and with that you get access to which as soon as you go there, you get you are allowed to vote. The very idea of a single electoral roll. Why a single electoral roll? Because a single electoral roll, the idea of a single electoral roll, or the philosophy behind a single electoral roll, means that in India there is no special electoral roll that is created on the basis of caste, creed, religion, gender, etc. Once you are at the age, you attain the age of 18 years, you are all eligible to become voters. You are all eligible to become voters, and it will not be decided which, you will, as soon as you register yourself as a voter, you get into one electoral roll. There is a single electoral roll, and you are the member of that particular electoral roll. Your voting criterias or qualifications are not decided on the basis of which gender you belong to, or which religion you are from, or which caste you belong to, any such things. which was previously the part, like we followed something as called as communal representation. We learned from that. We learned from that particular mistake, and we know that if we follow any such multiple electoral rolls, it is likely to create further divisions in the society on the basis of such criterias. And all such philosophy behind it. Now we talk about India being a democratic country, and what is meant by a democratic country? A country wherein citizens, it's all about citizens, and that is the reason why the very idea of fundamental rights are present, because fundamental rights, ensuring fundamental rights or ensuring application of fundamental rights does what? Citizens having, the citizens that are there, they are having the rights. The rights are not given to the states. The state cannot act arbitrarily. The rights are there for the citizens to enjoy, and this is what is meant by a true democracy. Clear? Similarly, when we talk about the idea of justice, or for that matter, even the idea of equality, so you would find that is the reason why the constitution has something called as directive principles, part 4 of the constitution dealing with directive principles. What is the objective of directive principles? Ensuring a socially and economically, social and economic democracy, or social and economic equality, or social and economic justice is the basic objective of directive principles. And all these provisions have been mentioned in the preamble itself. So what is a preamble? Preamble is an ideal or comprehensive expression of the philosophy or the ideals and aspirations of the people. So if I am asked a question, if I ever am asked a question that what kind of a society you would like to be a member of, ideally speaking, I would like to be a member of a society which has been mentioned, or the features of which has been mentioned in the preamble of the Indian Constitution. Clear? Why does the Supreme Court describe it as a key to unravel the minds of the constitution makers? Because in various decisions of the Supreme Court, you would find that the Supreme Court tends to refer to the preamble for if there is ambiguity, any ambiguity that is present on the various provisions of the Constitution, the Supreme Court tends to refer to the preamble of our Constitution, and tends to interpret that very provision in light of what the preamble has to say. Because this is what the Supreme Court feels. The Supreme Court also knows that the preamble, the preamble is like an expression of what the Constituent Assembly really wanted when it was, when it indulged into this comprehensive exercise of creating or enacting a constitution. What did it really want? It really wanted what has been mentioned in the preamble. And hence, if ever there is an ambiguity that comes up on various provisions of the Constitution, or any provision of the Constitution, and it is when the Supreme Court is interpreting it, or for that matter when the judiciary takes up its interpretation, it looks into this very idea that what is, if this is not very clear, let's look at what the preamble has to say. What is the philosophy behind it, and interpret the provision objectively by basing the decision or interpretation on what the preamble says. And that is the reason why the Supreme Court calls it as a key to unravel the minds of the constitution makers. Clear? Understood this idea? This is what is the preamble. Give a subheading. More importantly, write nature of preamble. Very important. Nature of preamble. When we say the basic structure, the preamble may not be the part of basic structure, but the philosophy behind it is definitely the part of basic structure. And from time to time, on various interpretations that Supreme Court has taken up, the Supreme Court has made these ideas to be the part of basic structure. Today, the idea of having a parliamentary democracy and a democracy is a part of basic structure. It has been declared that. Similarly, if you go to the ideas of Article 19, Article 20, Article 21, 40, Article 14, all of them have been declared as a part of basic structure. Again, the provisions, if you look at the provisions of the preamble, you would find it inherently present there. The idea of secularism being mentioned, कल भी हमने बात किया था, as a part of basic structure of the constitution, it has been mentioned in the preamble. Preamble declares India to be a secular state. So yes, if you look at the basic structure of the constitution, though the idea of basic structure, the Supreme Court has never declared that preamble is a part of basic structure, but if you look at the various decisions of the Supreme Court, you would find that what has been declared as a part of basic structure, it is ingrained in the philosophy of the preamble itself. Clear? Nature of preamble. First, it is not enforceable. It is not enforceable. What is meant by this? It is not binding on whom? It is not binding on citizens. It is not binding on state. See, non-enforceable means that it cannot be used by the judiciary to give any individual any right or impose any duty on the state. When you say it's not binding on the state, what does that actually mean? It actually means this, that suppose the Constitution of India or the preamble to our constitution mentions the idea of India being a socialist state. It declares India is a socialist state. But can we say today that India is actually a socialist state? In terms of economic socialism, do we follow economic socialism anymore? The answer to it is no, we do not. So I cannot go to the court and say that, see, because I'll approach the Supreme Court. Like yesterday itself, if you have read the newspapers today, you will find that yesterday our finance minister talked about disinvesting certain PSUs. Now she talked about disinvesting certain PSUs. Now I cannot go to the court and say that, see, India is a socialist state, and in a socialist state, resources belong to the philosophy is what? The resources belong to the state, and the state will strive to equally distribute such resources among its citizens. This is the very idea. So I cannot go to the court and ask that because socialism is a part of our preamble, hence such steps taken by the government are what you can say unconstitutional. I cannot claim this. Why? Because the philosophy that is mentioned in the preamble, or the ideals or the aspirations that have been mentioned in the preamble, they are not to be enforced, or they are not to be enforced by the court. The court cannot enforce it. Yes, the state might take up certain steps to enforce it, but on behalf of what has been written in the preamble, I cannot go to the court and ask for its enforcement. That is what I cannot do, and that is the reason why it is described as non-enforceable or non-justiciable. We say it is non-enforceable or non-justiciable. Clear? Second, it cannot override any specific provisions of the constitution, which means suppose there is an inconsistency between what has been mentioned in the constitution and what is written in the preamble. In that case, taking preamble as the grounds, I cannot, it will not override those grounds that are mentioned in the preamble, would not override those provisions that are mentioned in the constitution. If there is an inconsistency, Generally that is not the case, but if there is an inconsistency, so preamble will not override the other provision of the constitution. Third, it does not impose any limit to the powers of the executive, legislature or judiciary nor confers means gives, nor confers any substantive power to them. Which means the three organs of the state that are there, they do not derive any power because of the preamble, nor are their powers limited because of the preamble. So it does not give any power to anybody, nor does it take away any power from anybody. Like if we talk about the judiciary, so the judiciary does not get empowered because of what has been mentioned in the constitution. So the preamble cannot be used by the judiciary for the basis of judicial review. समझ रहे हो? That okay, this is mentioned in the preamble and hence we have the power to do this. That cannot happen. Similarly, the executive cannot claim that because socialism has been mentioned in the preamble, so we are going to establish a socialist state, and and economic socialism, that idea now cannot be claimed by the executive. And so if if tomorrow the state wants to take over, suppose some of the resources that Ambani has, ये जो है आज से state का हो गया, so this Ambanis might go to the court and the court might rule in favor of them, not in favor of the state. And even if the court rules in favor of the state that okay, yes, it can be acquired by the state, the basis of the decision will not be the preamble. So neither the preamble confers any specific powers, nor does it limit any specific powers of the of any of the three organs of the state. Clear? Have you understood the nature of preamble? So in generally I have seen aspirants making a lot of mistake here. होता ये है that sometimes when a question comes on nature of preamble, people tend to write introduction of the preamble and forget about the nature. Nature means you have to specifically describe what nature the preamble is of, what characteristics it has. You cannot just write that it is and ideals and aspirations. And I have seen that people start describing the terms that are mentioned in the preamble. That is absolutely wrong. If you do that, you get a 0. Yes, you can start the answer by writing an introduction as to what the preamble is, but the gist of the question, the most important aspect of the question of your answer should belong or should be revolving around these three ideas. Clear? And that is the reason why if you look at it substantively, preamble is just considered as a decorative part of the constitution. It is, in fact, it has been described by the Supreme Court as a decorative part of the constitution. Clear? It's merely decorative in nature. Clear? Next, give a subheading, right? Purpose of the preamble. Purpose of the preamble. So the question still remains, does the preamble serve any purpose, or because it has been declared as a decorative part, so it does not serve any purpose? But the thing is that yes, preamble does serve certain purposes. There are certain purposes that it serves. What are those purposes? Let's look at that. First, the preamble declares that constitution. The preamble declares that the Constitution emanates from the people, and the people are the real source of authority, of the Constitution. The Supreme Court in Kehar Singh versus the Union of India, Kehar Singh versus the Union of India from now onwards write in this manner. So whenever I say Government of India, don't write Government of India, GOI. Union of India, 1989 case has held that the Constitution emanates from the people, is a legal fiction, and an conclusive assumption which cannot be tested or questioned, in any court of law. See, there are two things that you need to understand here. First, underline ultimate source of authority of the Constitution is the people. Something like this I have dictated. Underline that. And also underline legal fiction. What is the meaning of these two ideas is what the basic purpose is. This is something that it serves. How does the preamble of the Indian Constitution start? We the people of India. देखो, the very idea of why Constitution is considered to be, or why people of India are considered to be the ultimate source of authority of the Constitution has been mentioned in these 3 or 4 words. We the people of India. Because it's not that the Constitution has been imposed on us. The expression we the people of India means what? The expression we the people of India means that it is we, it is us, it is the citizens of India who have adopted this Constitution, or who have given ourselves this particular Constitution. Which means this has not been imposed by an authority. This has not been imposed by an authority like the Constituent Assembly. If you remember, yesterday we did discuss this idea. No, we did discuss this idea that the Constituent Assembly was not an elected body. It was not a completely elected body. It was only partially elected. It was not completely elected. So if it was not completely elected, so tomorrow I can challenge this very idea that, see, because this body was not an elected body, India follows the idea of democracy. Supreme Court also says democracy is a part of basic structure of the Constitution. Hence, this Constitution itself is not valid because it has not been taken up by a body which we have elected. Or no, I can make such an argument. But the Constitution of India speaks of a phrase, we the people of India, which means that we ourselves have voluntarily adopted it, and we are not, we cannot challenge this on this very ground that it was taken up by a body or formed by a body which was not an elected body. First idea is this. Second, when we say we the people of India, Or when we talk about, why are we considering, or when we consider people of India to be the source of authority of the constitution, what does that mean? It means that when you see the term sovereignty that is mentioned as a part of our preamble, sovereignty does not lie in an institution, or sovereignty does not lie with the state. Who are the ultimate sovereigns? The ultimate sovereigns are the people of India. Sovereignty lies with the people, not with an institution. So we cannot say that once we have elected a body, the legislature, because it is an elected body, hence the legislature becomes a sovereign body and does whatever it wants. Nahi kar sakte. They cannot do that because they are not the ultimate sovereigns. Or even the judiciary cannot claim that the judiciary becomes a sovereign because it has the power of judicial review, so it becomes the sovereign. No, that is not the case. Judiciary, legislature, executive, all the three organs have to follow or have to abide by the Constitution of India. And the Constitution of India declares that it is we the people, so us, we are the ones who are exercising the authority. Why? Because Constitution derives its authority from the people. And whenever we talk about all the three organs, all these three organs have to also abide by the Constitution. So hierarchically speaking, people of India are the topmost. They are basically occupying that topmost position when it comes to the Indian hierarchy. Then comes the Constitution, and then comes the other three bodies. So this, the executive, the legislature or the judiciary, they are not the ones who are sovereigns. Sovereignty lies with the people of India. Clear? So the idea that Constitution of India derives its power. Yesterday when we were describing the Constitution, we said it is what you can say the most important law, the supreme law of our land. Why is it supreme law? It becomes supreme law because the power that it derives from the people of India. And this is something that is declared in the preamble. Legal fiction. The term legal fiction means the Supreme Court in the Kehar Singh case is very clear. That I cannot say that tomorrow see, when the Constitution of India was being formed, so I was not born then, and because I was not born then, so I will not accept the Constitution, because I have not voluntarily, I have not voted in favor of this. So I will, because I was born in India, I cannot be forced to accept the Constitution of India. This argument cannot be made, because when we say this idea that the Constitution of India, this idea of that it is deriving its power from the people, the Supreme Court says it is a legal fiction. It is very much enforceable, this idea. It is a fiction. I will not prove this. I will not have to prove this, or the court does not have to prove that this is a document that derives its power from the people, and it will not be tested in any court of law. The idea that the Constitution derives its power from the people, it is not to be tested in any court of law. This is what is meant by legal fiction. So I will not go to the court and start challenging that I was not born when the Constitution was adopted. So बाकी सब जो उस समय पैदा हुए उनकी बात अलग है, but not anymore. Not at least not me. I will not accept the provisions of the Constitution. This is not something that I cannot do. Clear? Second point. It provides a statutory recital. It provides a statutory recital. Statutory. What is meant by the term statutory? Statutory means anything that is legal, anything that is backed by a law. Anything that is backed by a law, anything that is legal is statutory. Is Niti Aayog a statutory body? Is Niti Aayog a statutory body? No. It's not a constitutional body. It's not a constitutional body, neither it is a statutory body. It's not a statutory body, neither it is a constitutional body. Why? Is there a law which talks about Niti Aayog? Formation of Niti Aayog? No. There is no such law. What is meant by statutory? Anything having a backing of the law. Does Niti Aayog, is there any law which talks about the Niti Aayog? No. It's not a statutory body. It is not a constitutional body. It is an extra statutory, extra constitutional body. Clear? Extra means something that is not legal or something that is not statutory. Clear? So non-constitutional, non-statutory. Clear? This is what is meant by statutory. And what have you written? It is a statutory recital of the ideals and aspirations of the people. Statutory recital of the ideals and aspirations. The ideals and aspirations of the people. Clear? Statutory recital of ideals and aspirations of the people. So basically it is legally reciting what we as Indians know, what we aspire for, and what, as a society, what do we want. Third, it helps in removing any ambiguity that may surround the constitution. Any ambiguity that may surround the constitution. As we have already seen, Supreme Court also has declared it to be key to unravel the minds of the constitution makers. And fourth, it contains the enacting clause. It contains the enacting clause which declares the constitution, was enacted on the 26th of November 1949. 26th of November 1949. It has nowhere else in the constitution the date has been mentioned except for the preamble of our constitution. Clear? And that is what is called as the enacting clause. Clear? Now, give a subheading, right? Is the preamble part of the constitution? Is the preamble part of the constitution? See, when we say that the constitution is a part of the preamble is a part of our constitution or not, there are two views that exists here. First is the traditional view. The traditional view has been put forward by the Supreme Court in the Berubari Union case. Berubari Union case, where the Supreme Court declared that preamble was not the part of the constitution and therefore it cannot be amended. In the Berubari Union case, which is reflective of the traditional view, is the fact that constitution is not, the preamble is not the part of the constitution, preamble is only decorative in nature. Now it is like an introduction, it is like a prelude, but it is not the part of the constitution. And because it has never, it's not the part of the constitution, hence the provisions that are mentioned under Article 368, that is with respect to powers to amend the constitution, that provision is not applicable to the preamble. And because it is not applicable to the preamble, and that is the very reason why you cannot amend the preamble. Clear? So we are going to talk about this particular case. We are going to repeat this case later on as well, and you would find that it says the Supreme Court was very clear in this case, wherein it said that no, the preamble is not the part of our constitution. Clear? Basically, this Berubari Union case was about, in the 1960s there was a territory, a disputed idea between India and Pakistan, East Pakistan, that is Bangladesh currently, and India wanted to for convenience in administration, India wanted to cede a certain part of territory to Pakistan, which they claimed, and there was an agreement and we wanted to do that, but in the Berubari Union case it was challenged that the idea of sovereignty that is there, which has been mentioned in the preamble, and how that idea of sovereignty is there and what does that mean, it was challenged in this particular case, and in that very case preamble was declared not to be the part of the constitution. But the Supreme Court overruled this idea in the Keshav Nanda Bharti versus the state of Kerala 1973 case, again a case which we are going to frequently talk about, and in this case the Supreme Court overruled its earlier decision . Overruled its earlier decision and declared it to be the part of the constitution, and therefore can be amended. Therefore can be amended. And accordingly, by the 42nd Constitutional Amendment Act, by the 42nd Constitutional Amendment Act 1976, the preamble was amended and the term socialist, secular and integrity. The term socialist, secular and integrity, these terms were added. These terms were added to our preamble. 42nd Constitutional Amendment Act. So the term socialist, secular as well as the term integrity. This constitutional amendment was done on the recommendation of a committee which was headed by Sardar Swaran Singh. He headed the committee, and that very committee recommended that these three terms and along with some other provisions should be added to the constitution. We describe the 42nd Constitutional Amendment Act famously, informally, as mini constitution. Why? Because the 42nd Constitutional Amendment had made a lot of changes to the Constitution. It made a lot of changes. We are going to talk about it regularly. Regularly you would find we are talking about the 42nd Constitutional Amendment Act. Obviously time देखो 1976 है, which means it was during emergency. Because it was during emergency, so it was easy to take up such an amendment. Now it was easy to take up such an amendment because most of the opposition leaders who were opposing who were in capacity to oppose any such amendments, they were in jail. So it was very easy to pass such constitutional amendments. Clear? And after this 1977, Indira Gandhi loses power, elections are held, Indira Gandhi loses power, Janata Party comes to power, and Janata Party takes up what you can say the 44th Constitutional Amendment. And the 44th most of the provisions of the 44th Constitutional Amendment was to undo the provisions of the 42nd Constitutional Amendment. Clear? So this is something that goes on. The term 42nd, 44th that we are talking about, you have to remember them. So I am not going to see in terms of cases that I discuss only the relevant cases. I am not going to discuss all of the cases. I am only going to discuss the relevant cases. At least these cases you have to remember by heart. On all those cases that I discuss in the class, you have to remember those cases by heart. Along with it, sometimes you get certain cases which are which come up because of what is going on in current. Otherwise, in terms of traditional cases that are there, in traditional cases if they pick up, in that case we are going to deal with all those cases. You have to remember them. Sometimes they tend to do what? Sometimes they tend to take up certain cases which are not that important, which we may not discuss in the class, but it is asked there because it was in news. For some reason it is asked. Like going back to the year 2015 or 16, I think 16, 2016 mains examination, there was a question asked on the 69th Constitutional Amendment and a case called as the Kohilo case. And we do not generally discuss it in the class. The reason was that the case was about whatever was going on between the Delhi government and the LG, and that was something that was very much in news. So that was the reason why that particular case was asked. Clear? So all those cases that we discuss in the class, these cases and the constitutional amendments that we discuss in the class, these constitutional amendments and these cases are of utmost importance. You have to learn them. Now you have to learn them. So don't come to me after the class and say that, sir, सारे cases याद करने हैं क्या? Yes, at least those cases which we are discussing in the class, you have to learn those cases. ठीक है? So this is what the preamble, whether it is a part of our constitution or not, it has been mentioned in these two cases by the Supreme Court. Now, coming to preamble, there are let's discuss the meaning of the terms that are mentioned in the preamble. Let's go through the basic ideas that have been mentioned. You would find that sometimes this is the question that is asked. Now, what are the terms that have been mentioned, like sovereign, socialist, secular, democratic, republic, the ideas of justice, equality, liberty, fraternity? What does these ideas mean? Let's start with that. The first term that is mentioned is called as sovereign. Clear? Give us a heading, right? Sovereign. If you are in that habit of first writing what the topic is about, so then write values mentioned in the preamble. No, you can introduce it in this manner. Values mentioned in the preamble. And the first value is sovereign. Again, going back 2 or 3 years, this question was asked. What are the values that are mentioned before the term republic? Before the term republic, and are those values relevant in current context? Describe. This was again a question that was asked. So let us look into that idea and let us understand that if you look at it from the current context, is these values that are there, are they relevant or not? First, the idea of sovereign or the idea of sovereignty. Now, what is meant by a sovereign country or sovereignty? What does that mean? Self-ruled. Yes, self-ruled. Absolutely correct. This is the meaning of the term sovereignty. When the country is free from any external or internal pressure, when the country is free from any external or internal pressure and is responsible for taking its own decisions, that is what is a sovereign country. That is what is a sovereign country. You would find that we have actually taken up, or you must have heard about this term sovereignty a lot. In this specific context, recently what happened in the state of Jammu and Kashmir, how we actually amended the constitution. We amended article 370 of the constitution, and now you would find that article 370, which still exists in the constitution, but it has been substantially amended. And now what is mentioned is article 370 clause 1, that's it. Other things have been removed from the constitution. Now in that context, it was, there was an internationalization of the issue. There were lot of these things that were discussed in the UN. It was discussed, the Pakistan took up this issue, even China supported it very recently when UN General Assembly met. So countries such as even Malaysia and Turkey took up this very idea, internationalized. And whenever India talks about article 370, we always say India is a sovereign country. We mention this idea, India is a sovereign country, and issues such as article 370, which deals with Indian constitution, are it is something that is an internal issue or an internal matter for India. India, being a sovereign country, is has the authority to decide on such issues. This is what is meant by sovereignty. That is, any decision that we take, any decision that we take those decisions without any influence of any external or internal powers, without any influence of any external or internal powers. Clear? This is what is meant by the term sovereignty. Clear? Now, what you also need to understand is that if we talk about the ideas of sovereignty, there are certain things like India being a member of UN or India being a member of Commonwealth countries. Do you know what is a Commonwealth? Yes, what is a Commonwealth?
Previously they were colonies of Commonwealth.
Yes, previously they were British colonies, and they have come together and they have recognized the British monarch. No, that is the Queen as of today. The British monarch has been decided as, or it has been considered as the head of Commonwealth, and India is a member of Commonwealth. Clear? So because they share a certain tradition, or we share history with these countries. Now because they were also colonies, British colonies, we were also a British colony. So because we share history with these countries, we have come together and we have formed an institution which is called as the Commonwealth. In 1949, and India became a member of Commonwealth. So whenever we talk about India being a member of UN or India being a member of Commonwealth countries, do you think this in any way challenges, or limits India's sovereignty? Yes or no? If yes, why? If no, why? Why no? It, in a certain way, it challenges. In what way? It needs to be abided by India. Okay.
If India has abided, saying on India,
it is legally binding. Okay. So who says no? Why no? It is voluntarily done by India. See, both these arguments are correct. Both these arguments are correct. Is India being a member of such organizations such as the Commonwealth or the UN, does it challenge or does it influence the sovereignty that India has in terms of its decision making? To a certain extent, yes. To a certain extent, yes. But legally speaking, no. What does this mean? Why I am saying yes to a certain extent, but legally speaking, no? Because legally you have to take this perspective that can India at any point of time give up the membership of UN? Yes. Even if it comes to some conventions that we follow, UN conventions that we follow, yes, though these conventions are legally binding, but these are legally binding in this sense that we have voluntarily accepted it to be binding. The day we decide that we are not going to follow such conventions, it is no more legally binding on us. It is no more legally binding on us. So, voluntary, because we have voluntarily accepted to be the part of Commonwealth, we were not forced into it. Similarly, we were voluntarily the part of UN, we have not been forced to it. That is the reason why legally we cannot say that it challenges the sovereignty of India, which is also the view of the Supreme Court. The Supreme Court has actually given this argument that it is not something that is challenging India's sovereignty. It is not challenging India's sovereignty because India has voluntarily accepted to be the part of these organizations, and at any given point of time, if India wants, India will not be a member anymore. If they decide to cease to be a member, that is also absolutely fine. Second, when it comes to this idea, like the question was contemporary relevance of it. So contemporary relevance of it, yes, in that context it becomes yes. Why? Because you can see, despite the fact that even if the UN or such organizations that they were made to be the part of this issue, like Article 370 and India specifically amending Article 370, despite the fact that it had effectively no consequence on what organizations such as Human Rights Commission, UN Human Rights Commission decide, but still we diplomatically endeavored not to be ruled against. ठीक है, हमने कोशिश किया that it should not be, any such ruling should not be against us. So you would find Human Rights Commission, similarly the Security Council, all of them were involved under what was going on under Article 370. What happened? So there was an issue, there was a meeting, then informal meeting of the UN Security Council, and in the informal meeting of the UN Security Council, it decided, the Security Council decided that this idea will not be pursued. Why did it decide that this idea will not be pursued? Because India diplomatically engaged almost all the members of the UN Security Council. The idea here is that if you look at the current scenario in terms of the global world or the globalization, the phenomena of globalization, and today we are guided by something called as a principle of universalism, wherein we tend to have some common definitions like human rights kya hai. When we are trying to define what is human rights, we are trying to come up with a common idea of what human rights is. Dictated, it is something that will be that we endeavor that this idea of a definition that we come out with is accepted by all. So today we live in an era of universalism, and in an era of universalism wherein we are guided by some common values, yes, the idea of sovereignty is definitely affected by such institutions, because when an organization such as the UN tries to pursue some ideas like human rights, or for that matter sustainable development goals, etc., these are certain common values, and we are affected by it. Our sovereignty is affected by it. We tend to take decisions so that we comply with certain norms, but it is contemporary. Legally speaking, the idea of sovereignty is not affected. India is legally a sovereign country. अब बोलो.
Yes, sir. Same question I was.
So this is the idea of sovereignty. क्योंकि हम एक universal, we are trying to follow this very idea. That is the reason why it is affected. ठीक है? This is where we end today. Tomorrow when we meet, we are going to take up this idea. No, yes. Tomorrow when we meet, we are going to take up this idea. We are going to complete the preamble tomorrow. And then we move to the part 1 of our constitution, that is union and its territory. Thank you.